Ms. Modis, what case are you here on?
Credit acceptance versus Williams.
All right. So you're here for credit acceptance?
Yes.
All right. And I don't see Miss Williams. Oh, there she is. All right. I see Miss Williams. Pam, you're Nicole Williams?
Yes.
All right. I don't see anybody else in the way. All right, let's call to the record docket 1904573. Credit Acceptance Corporation versus Nicole Williams. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
Nicole
And
Williams.
ma'am, okay, you are Nicole Williams?
Yes.
All right, this is the time set for a objection today. There was an objection to the order regarding installment of payments. This was filed by I believe this was filed by yourself, Ms. Williams. Is that correct?
Yes.
No, all right. And motion for installment payments. My understanding is that this was filed by you. I don't see a date on this. But in regards to installment payments, and then there was a Ms. Monis, I have another civil file. Did you file a response to that objection?
I did, Your Honor. I filed my
All right.
response on November 7th.
Right. Have you had the opportunity? I see that. Have you had the opportunity to speak with Ms. Williams about this to see if this can be resolved, or I'm welcome to hear any type of objection or motion if the parties want to proceed that way. But it's up to you.
So I have not had an opportunity to speak with her today. When she got notice of the garnishment, she did contact our office. However, our client isn't willing to set up payment plans when they have an active garnishment. So unfortunately, we would have to proceed today and have the court rule on a motion for my client to abide by that. But I do have a couple of points I would like to say about her motion, if I may, Your Honor. I don't know if you want me to now or if you'd like to hear her first.
Well, let's hear Ms. Williams first. Ms. Williams, this is your motion in regards to the objection, and I do have your order. It's the defendant must pay $100 a month starting December 28th, 2022. Is that my understanding? Ms. Williams?
Yes, that's right. Yes.
All right. And is you have an objection to that, ma'am?
Yes, I do, Your Honor. So there's a couple reasons why we object. We object because, one, this is a 2-year-old judgment. The defendant has not contacted us or made payments since the date of judgment. She's only contacted us now when there's a valid garnishment, which is typical. However, the bigger issue is at $100 a month, with her balance being as high as it is, it's going to take an additional 11 or more years to pay this off. And unfortunately, that's just not reasonable to have my client wait another 11, 12, 15 years to have this judgment paid off. So I would ask for a higher payment. We did request $500 a month, which would bring it to a 2-year repayment plan. So that's where my client stands as of today. But again, I mean, $100 is just too low. I can understand based on what she put for her income that $500 might be too much. But we would just ask for a number that would reduce the term of the payment plan to get my client paid off sooner.
Ms. Williams, you understand the objection to the installment payment plan as, I mean, this would take you an additional 11 years to pay off. Do you understand that?
Yeah, I do. And I didn't realize this was out here. The car's been over 4 years since I even seen the car. My husband had it, and then that's all I knew about it until my garnishment started.
I understand that. That doesn't change
Yeah.
the fact that you owe that. That's
I know,
unfortunate,
but
but it
I,
doesn't change the fact that you owe the money.
I know, but that's why I'm saying I didn't know about it. I just said it's
Right.
been 2 years, and I just no.
Is there a payment plan that is over $100 that would be acceptable to you, but still would allow us to have some earlier date than 11 years, which I tend to agree with Ms. Monas, seems to be unreasonable. It also seems to be a recipe for failure to put it
Yeah,
out that long. So is there an amount that would make it over $100 that you would be that would be at least bring it down below the 11-year mark, but would still be acceptable?
I mean, I could push for 200 and just try to get another job. I guess I don't know. I mean, I was out
Ms.
of work.
Notice, given the circumstances, I think if Ms. Williams were to make it 200 a month, that would at least knock it down by, I can't do the math on that, but I mean, it would at least be half, at least a 5-year plan or 5.5-year plan, as opposed to an 11-year plan.
Right. And I agree, Your Honor, that's definitely better. But we do also have to keep in mind that statutory interest is accruing as well. So her current balance right now is about $12,500-ish. So her interest alone per month is about, $125. So that's another factor we have to consider, is that, she has to make a payment that's going to cover that interest so it doesn't prolong the payment plan, as well as putting a dent into the principal. So we do have a reduced payment plan term. But, again, at this point, if that's what she can afford, I understand. I guess I would just say maybe we could have that for a year, and then after a year review and see where she's at to see if we can have higher payments. So that way, as you stated, we can reduce the length of time that it's going to take to pay this debt off.
Miss Williams, I think you can go ahead and make your argument. I think $100 is too low, and I think $500 is too high, at least for your income level.
Right.
I think an acceptable plan for a year to look at would be $225. That'll take out $100 interest, put $100 towards the actual debt, and at least put you in mind of a reasonable goal. Would that be workable? The extra $25?
I mean, I'm not even working now, and that's about how much they're taking out.
How about this? How about for the first
No,
6
actually
months?
taking that out of their pay period. I'm sorry. So yeah, it would be not every pay period. It would probably be okay.
It'd be one. It would only be once a month. It would be once a
Right.
month, a $225 payment.
Right.
Well, understanding the parameters that we're working with here, I'm going to accept the objection regarding the installment payments. I'm going to set the payment to be $225 every month. Starting, go ahead, Ms. Mons.
I was going to say, if you wanted to start at January of next year, that would be fine. That way it would give the defendant about a month to recoup. I'm not sure if there's anything pending right now from her wage garnishment, but again, that would give her some time to kind of recoup and make that payment the first of the year.
All right, so we'd move it to January 1st of 2023. Set aside I think the garnishment is set aside, isn't it, right now?
It's not set aside right now. With the installment payment order, it will be suspended. So if she does default, we would have to file a motion with the court that states she defaulted, and then the garnishment would be reinstated, but it would not be set aside or dismissed.
All right. All right, so we'll suspend the garnish payment in regards to the new installment plan starting on January 1st, 2023 of $225 every month. That'll keep us from, and then I'm willing to revisit this in a year, Ms. Nonis, depending on the status of Ms. Williams. But it's a substantial debt, unfortunately, for our purposes. Ms. Williams, do you have any questions of me concerning? It's $225 every month starting January 1st, 2023. We'll set aside any garnishment with that understanding of the order. Do you have any questions of me, ma'am?
So what you're saying that what they've collected already is just being set aside, and they're still going to collect for December?
Go ahead, Ms. Monis.
So as of today, Ms. Williams, when the court enters the order, your job is going to suspend the garnishment. Now, if they have anything that's being withheld until today's date, yes, we will receive some type of fund. So I'm not sure when your pay periods are, but for example, if you were to get paid next Friday, they should not withhold. If you were to get paid today, you'll probably see a withholding. But I'm thinking if it's kind of like our biweekly payments, your paycheck won't be till next week, which they should have time to receive the order by then. So you should not see another garnishment
Just
for
payroll
December.
on Monday. She does payroll on Monday. Sorry, I have COVID right now.
So what I would suggest then is try to get, Your Honor, if you could send us an order of the copy, even, or a copy of the order, even if it's to me, I can try to get it to the defendant as soon as possible. So that way she can take it to her employer. I wouldn't mind to fax it to her employer or whatever she would need. And that way, hopefully we can stop that garnishment from occurring on Monday. But I can't make any guarantees, Ms. Williams.
Right. I was thinking about that. I have Miss Williams' order in front of me, or the order regarding, hold on. Let me see. Miss Williams, I have your order in front of me.
Yeah.
And in order to expedite this, to get this, I have the defendant must pay judgment installments as $100 every month starting December 28th. I'm willing to change that on the record in your order with your permission to $225 every month starting January 1st. Sign it and then fax that copy over to Ms. Monis so we can get it to your employer as soon as possible. If you're amenable to that, I'll go ahead and make the amendments on your order, and then it's already typed up.
Okay.
Will that work for you? The only thing we're doing here is just trying to expedite it so your employment understands that the garnishment should be suspended.
Right.
All right. I'm going to go ahead and do that, and then we'll see what happens. I'm going to cross off 100. I'm going to initial it. I'm going to put 225. I've also indicated that for the register of actions. I'm going to cross out the date and put January 1st, 2023. I'm going to indicate that per permission of Williams. This is, of course, all record, but pursuant to permission from Williams, I'll sign the order. And then do you have a number that you'd like it to be emailed or faxed to, Ms. Nonis?
Sure, you can fax it to 586-576-1708. And I will keep my eye on it. And then Ms. Williams, it doesn't look like we have a contact for your employer. Do you have a person or a phone number that I can call so I can get a hold of them today?
Yeah, I do.
I'm ready when you are.
Just a second. Oh, it's actually in my car. Okay, hold on.
Well, that's okay, Miss Williams. Why don't we do this? After the hearing, just call our office and provide us that information, okay?
Okay.
Yeah, when you provide them that information, they'll have a place to send the order and that'll suspend any garnishment. And I believe, Mike, we have that number. Okay. All right, so just for the record, the 200, I've changed the order and initialed it per permission of Miss Williams so that we can fax that order over to the attorney of record. It's $225 every month, starting January 1st, 2023. That'll set aside any or suspend any garnishment. Anything else for the record in 1904573, Ms. Nonis?
No, Your Honor, thank you.
Anything else, Ms. Williams?
Oh,
All right, if you get that information to Ms. Nonis concerning your employer information, that'll expedite this, trying to get this done today, okay, ma'am?
yeah.
All right, that's all for the record in 1904573. Everybody have a nice day. Thank you for your appearance.
Thank you, Your Honor.
We're on the record in docket 06-04597 GC, Midland Funding LLC versus Janice Kennedy. I should change that. This is the time set for an objection, another objection to garnishments that were being held. This was scheduled for 8:30. It is now 8:57. Neither party has appeared.
Your Honor,
Oh,
I'm here for Kennedy.
you here for Kennedy? Come on up, ma'am. Come on up, sir.
Come up, sir.
Go ahead and come on up. Yeah. I'm sorry, I didn't know you were here.
That's all right.
So, so your appearance for the record.
Kenneth Kennedy, Janice Kennedy's husband, EPOA.
Okay. And there's not a representative from Midland Funding LLC here. I don't see anybody in the courtroom. I don't see anybody in the Zoom courtroom. And as previously indicated, it is 8:57. This is called at 8:30. This is I believe this is your objection, sir, correct?
Yes, sir.
Would you like to proceed? I don't have an opposing party, so at this time, I'm inclined to, I'll hear your argument, and then I think we'll go forward. This would be a default judgment because the other party's not here.
Sure.
But I don't have the filing out of your objection. I don't have any boxes checked for the order. So if you could indicate for the record what you're asking for today.
So, Your Honor, I was unaware that my wife had this account since 2006.
Okay,
So when I received this in the mail, my wife last year became very ill. And so I've been managing all the finances. So when I seen this come, this garnishment on our taxes, I had to address it. It looks like to me, the total bill was $843 and a penny. And over a course of time, she paid a total of $690,
all right.
which left a balance of $152 to satisfy that $843. Moving fast forward in 2022, it gained some interest of $192 interest, and now the filing fee, I guess, for the representative of an additional $120, which brought that up to a total of $465. So, Your Honor, I was unaware of this, and this was the first contact. This could have been, I don't know if phone calls were made. My wife is unable to articulate herself, and so I'm managing everything. I'm finding things that I needed to address to get up to speed.
Right, and I saw that you filed the durable power of attorney.
Yes.
Okay. But there's no objection to, I mean, it's a default in regards to your objection to the garnishment. If there is an acceptable plan for you to pay this off within a certain period, you know.
So
I mean, we're not talking a huge amount of money,
no,
but I'm also don't want to belittle the fact that you have other accounts that you have to deal with.
I understand. So I was hoping today, what I was hoping today, Your Honor, is that either I would like to pay this, I would like to move forward and just close this out.
Okay.
But I feel that the interest that was accrued over a period of time is and not no notification.
Right.
I feel like the $192 I shouldn't have to.
What is the balance without the interest? Without the interest, if assuming they notified in a timely manner.
Sure. So it would have been 152 and 120, 270 roughly.
All right. So I don't want to fill out your order for you. If you fill out an order to that effect, and I'll indicate it for the record that the plaintiff failed to appear.
Mm-hmm. Yes,
I'm gonna grant your objection and order that defendant pay minus statutory interest the amount of, what amount do you have?
I
minus,
have 465.30
minus
plus minus 270.
And if you give me that, I'll double check your numbers.
Yes, sir.
465.30
Yes, sir.
minus 270.
Right. So I'm looking at 185. Did I get that right?
It's 195, but let's do it again because 465.30
Yeah, 190
minus 270. I have 195.30.
Yes, sir.
If you submit an order to the court that is what you're requesting in regards to your objection to the garnishment,
yes, sir.
That would be acceptable to the court. I've indicated that for the file, and you can. How soon can you pay that, sir?
I'm prepared to do that today.
All right. So upon my signing of order, and we get that to the parties, you can make payment for that amount. Okay.
And who do I?
I would assume you make it to Midland Funding LLC.
All right. And part of my ignorance, Your Honor, the order, is there a document that I need to go get that?
It's that document, isn't it? Yeah, it's this document that you've already filled out. I'm gonna give it back to you.
Yes, sir.
And then if you submit the document, I know Nathaniel's not here, but if you submit the document for my signature with the changed numbers on it, and that was my confusion, is it's this document, but it wasn't filled out, that medium part, which I know can be confusing.
Yes, sir.
If you have any questions, you can take it to the civil department, right here on the 6th floor.
Okay.
Yeah, and they'll help you fill it out, but you have a number now to put in for me to sign.
Yeah, so just to reiterate, if I may.
Sure. Nathaniel, you want to give this order back, and he's gonna fill out the number that we've just come to in regard to the objection.
So it looks like, Your Honor, it would be 270.30. 30 cents that they have, which is fine.
So well, now let's get I have the 465 minus
It's actually 465.30.
465.30
Yes.
minus the,
Are we doing the 192.36?
yeah, that's what I had.
Yeah, sorry.
So that's the final numbers, 195.36 minus the interest that accrued during the lack of contact time period, while you were getting a durable power of attorney for your wife, which I think is fair.
Again, Your Honor, part of my ignorance, just looking at the numbers, the 465.30 was the total. And then if we take out the 192.36,
No, that's how I got to 195.36, was taking out the 270. Yeah, that was the interest, right?
no, the interest was actually 192.36.
All right.
That was the interest.
So 465.30 minus the 195.36.
The 192.36.
192.36. I come back to a total of 272.94.
Yes, sir.
All right, that's the number. So that's the number to put on the order for me to sign.
All right.
And that would be that. So that would subtract the interest.
Yes, sir.
If you fill that order, and if you need any help, they'll help you at the civil department.
I'll go up there. It's still kind of confusing.
Okay.
These documents.
All right. The 272.94 is the 465 minus the 195.56 interest. So we get down to a 272. And once I sign the order, you can make payment to the Midland LLC.
All right. Do I bring that back down here? Or do I just send it in the mail?
Yeah, you can live it with the civil department. They'll get it to me to sign.
On the 6th floor.
Yeah. Yep. Yeah, it's on the civil department's on the 5th floor.
Oh, excuse me.
But they'll get it to me to sign. Okay.
Yes, sir.
All right. Do you have any questions on docket 106-459-45976, Mr. Kennedy?
No, sir.
All right, you're all set. I think we figured out a number. If you get to the civil department on the 5th floor, so they can help you fill it out, I'll get it, I'll sign it, and then you can make the payment to them.
Yes, sir.
Then if they have an objection, they have an objection, but they didn't appear today.
I
Okay.
understand.
All right.
All right.
Thank you, sir.
Good day.
You too. I don't see any. I don't see on the record in docket 2202-995. That's people of the state of Michigan versus Tommy Tomi Thayer. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Your Honor, Eric Tomal for defendant who's present in the courtroom.
Thank you, Mr. Tomo. And ma'am, you are Tommy Thayer?
Yes.
Okay, and you can hear me all right, Ms. Thayer?
Yes.
All right. Ms. McComber, this is the time set for a preliminary examination today. How are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in this matter. We'd ask that the case be bound over on the charges in the complaint.
And negotiations are to continue.
That's correct, Your Honor.
And Mr. Tomal, that's your understanding?
Yes,
Okay. May I inquire of your client of the waiver?
yes,
All right. Ms. Thayer, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, ma'am? And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a felony was committed in this matter and then the identity of the person who committed that crime. Do you understand that?
Yes.
Okay, and the parties, the prosecutor and your attorney, Eric Tomal, have indicated that negotiations are to continue as they've indicated, but it is your wish today to waive your right to a preliminary examination and have this case bound over to circuit court.
Yes, Your Honor.
Okay, is that your wish today?
Yes, Your
Do you wish to waive your right to a preliminary examination?
Honor. Yes, Your Honor.
All right. I find the waiver to be freely, understandingly, and voluntarily made. I waive this up to circuit court. Negotiate, my understanding at this time, negotiations are to continue. To continue. The waiver is done freely, understandingly, and voluntarily made. Both parties have indicated their wish to waive the preliminary examination. So ma'am, please keep in contact with your attorney, Eric Tomal, and he'll get you the next date you have in circuit court. That would be the trial court. Your time in district court is done now, okay, ma'am?
Yes, Your Honor.
Anything else for the record in docket 22-02995, Ms. McComber?
No, Your Honor.
Anything, Mr. Tomal?
no, thank you.
All right, that's all for the.
This one as well, please.
Yes.
Does this probably should be on the record. Signing the document. I don't know which form you have, but some have a place for you to sign and some don't.
Yes.
So, thank you, Mr. Tomal.
Yes.
All right. Okay. And then, Ms. McComber, did you have another case to call?
Yes, Your Honor. Karen Curtis.
So we're on the record in docket 22-02996. That is the people of the state of Michigan versus Karen Curtis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Macomber on behalf of the people.
Matthew Samuels on behalf of the defendant, Ms. Curtis, who is present and standing to my right.
All right, thank you, Mr. Samuels. You are Karen Curtis? All right. This is the time set for preliminary examination today. How are we proceeding today?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in this matter. We ask that the case be bound over on the charge of the complaint.
Okay. So it's my understanding, Mr. Samuels, you've heard the prosecutor speak in this matter. Is that your understanding of what we're doing today?
That is, Your Honor.
All right. So may I inquire your client of the waiver?
Absolutely.
All right. Ms. Curtis, you understand you have the right to a preliminary examination within 21 days of date of arraignment. Okay, and the preliminary examination is a probable cause hearing in which the people of the state of Michigan would prove and would have to prove that in this file, a felony was committed and the identity of the person who committed that crime. Do you understand that, ma'am? All right. And Mr. Samuel would be here to cross-examine any witnesses and contest any charges brought against you. It's my understanding after listening to both lawyers speak today it's your intent it's your wish today to waive your right to preliminary examination today and have negotiations continue in circuit court. Is that true?
Yes.
Okay, so it is your decision today to waive your right to preliminary examination. All right, I find the waiver to be freely, understandingly, and voluntarily made. Negotiations are to continue in circuit court. My understanding is both parties are waiving, so the prosecutor also will waive. Keep in contact with your attorney, Mr. Samuels, in regards to any date in circuit court. For any circuit court purposes, your time in district court now is finished. All right, ma'am? Anything else for the record in docket 22-02996, Ms. McComa?
No, Your Honor.
Anything, Mr. Samuels?
No, Your Honor.
All right, thank you. Good luck to you. Okay,
Do we need to sign something?
yes, you have to exactly the same.
That's what I
Yeah.
make sure before we start
Yeah.
leaving.
Mr. Samuels, if you could approach, I have a short leash. I try to
No
strangle
problem.
myself often.
Right.
Thank you. Yes, Natalie, it happens more than you think.
I saw that on the main. If you bring that up, Mr. Samuel, I'll take that. and
I
sign
am
it.
doing that.
Thank you.
Thank you. You have a good rest of
You
your day.
too. Ms. Robinson, is that your client?
No, Your Honor.
No,
It is
Mr.
Mr.
Palmer's
Palmer's client.
Mr. Palmer. That's Mr. Thayer.
Yeah.
Okay.
I think we're trying to get Miss May Palmer's case.
All right. Ms. Robinson, your client's Mr. Richard? Okay,
Yes, sir.
all right. Good morning, Nick. How are you?
Yes, sir, you?
Pretty
He
good.
was in the hallway. I just heard him. He rushed
Okay.
out.
Mr. Palmer?
Yeah. I just heard him. I'll go let him know. Thank you, Mrs. Robinson. No problem.
on the record in docket 2202-994, people of the state of Michigan versus Tommy Thayer. That's Tommy with a Y. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Beckham on behalf of the people.
And good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Thayer, the gentleman who stands to my right.
And sir, you are Tommy Thayer?
Yes, sure.
All right. This is the time set for preliminary examination day. Ms. McComber, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving their right to hold a preliminary examination in this matter. We'd ask that the case be bound over on the charges of the complaint.
All right. And is that your understanding, Mr. Palmer?
That is an accurate statement, Your Honor. We are voluntarily waiving the preliminary examination today. The only other matter is my client would like me to address bond.
All right. May I inquire your client of his waiver? All right. So you understand, Mr. Thayer, you have the right to a preliminary examination within 21 days of your date of arraignment. You understand that?
I do, Your Honor.
Okay. And the preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. Do you understand that, sir?
Yes, sir, Your Honor.
Okay, by waiving your right to a preliminary examination today, you'll be leaving district court, you'll be moving on to circuit court for trial, and your time in district court will be finished. Do you understand that?
I do, Your
You,
Honor.
of course, are represented by attorney Mr. Palmer from the Public Defender's Office, and he would be present and continue to contest any charges and cross-examining witnesses brought against you. Do you understand that?
I do, Your Honor.
Okay.
Yes, sir.
Is it your intent today to waive your right to a preliminary examination in this file based on the attorney's indications? Negotiations are to continue in circuit court.
Yes, sir, Your Honor.
All right. I find the waiver, and my understanding is both parties are waiving today. The people are also waiving their right to a prelim. I find the waiver to be done freely, understandingly, and voluntarily made. With the waive prelim. And any additional dates in circuit court where your new dates will be, you'll get through your attorney, Mr. Palmer. Do you understand that?
I do, Your Honor.
All right. Anything else for the record, Ms. McComber, on any non-bond related material in regards to this file?
No, Your Honor.
Anything, Mr. Palmer, non-bond related?
Non-bond related, no.
Okay. And then if you'd like to address bond.
Thank you, Your Honor. I would. I'm asking that the court consider a reduction of bond or a personal recognizance bond for Mr. Thayer for a couple of reasons. First of all, previously, he did not have an address. He was essentially homeless. He does have a stable address that he can reside with now. That's with his good friend Niles. The address is a Lansing address on North Grand River. And I can provide that to the court should the court grant a personal recognizance bond. I would also point out that Mr. Thayer could be monitored by other means. For example, he could, I believe he could be properly monitored, screened by JSG tether or GPS tether, I should say. And I certainly believe that Mr. Thayer would qualify for indigent status on that. But there are a couple of concerns that Mr. Thayer has, which I recognize, and which he's unable to address while he's sitting in jail or unable to properly address. Mr. Thayer has some cancer. It's a skin cancer. It's on his back. He has seen the medical department in the jail for that. They have tried to treat his pain, but my understanding is they don't have all of the ability to treat sort of the underlying root of it. They just can manage the pain. That cancer is starting to spread on his back, and my understanding is he does need some surgery. It's not by any means extensive, but it's the type that, you know, where they do outpatient and have to cut out some cancerous spots on his back. I recognize that my client does have some criminal history, but my understanding, one, it's been a little while since he's had any significant criminal history. Recently, also, I don't believe he's ever failed to appear for court before. My client also has some, I guess I'll call it struggles. My client was shot in the head when he was 11 years old. He's received Social Security his entire life. He's worked with Peckham a good chunk of his adult life. He intends to go back and work with Peckham again, should he be released, where he can get both job opportunities, but also some counseling and some services through Peckham. I would ask that the court consider a reduction to a personal recognizance bond for those reasons, Your Honor.
Thank you. Ms. McComber, prosecutor response.
Thank you, Your Honor. Your Honor, at this time, I would ask the court to leave bond as is. Mr. Thayer does have a quite an extensive criminal history that dates back to 1989. His most recent conviction being in 2016. And those convictions span from assault and batteries, domestic violence, felony domestic violence, and animal fighting, as well as rape, bodily harm, arson, murder. As far as this case itself, Your Honor, while I understand that Mr. Thayer may have stable housing, I don't believe that that housing has been vetted by pretrial services or has been, that they've been able to make sure that it is a actual, stable, safe housing. I don't really have a response to the cancer treatment other than I understand that the jail is working with what they can. The biggest concern, Your Honor, in this case is, as this court is well aware, this is a 3 co-defendant case, Mr. Thayer being the common denominator between all 3 parties at this point, Your Honor. One of the co-defendant is his daughter, the other co-defendant is his longtime girlfriend. I do believe there would be some conversations had between the parties if Mr. Thayer were not monitored, and I don't believe a GPS monitor would be able to adequately allow for that. Other than that, Your Honor, if the court is considering reducing bond, I would just ask to have pretrial services vet the address and the resident of that home before allowing him out, and ask that no contact order remain in place between the co-defendants.
Thank you. Based on the 5 counts presented that the bind over has been made on, and the prior criminal history, and the fact that this is a co-conspirator case, I think bond is appropriately set for this matter. Treatment is one of those things that have to take place in incarceration, but I'm going to deny the motion for bond.
Understood.
Anything else for the record in docket 2202994? Ms. McComber?
No, Your Honor, thank you.
All right, Mr. Thayer, you'll be in circuit court. Please keep in contact with your attorney, Mr. Palmer, okay? The other one I didn't write it.
It's hard to say.
Sign that. We're on the record in docket 22-03046. That is Dejun Richard, People versus Dejun Richard. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Richard, who's seated to my right.
And sir, you are Dejun Richard?
Yeah, correct.
All right. This is the time set for a continuance to a preliminary examination. It was started on November 23rd, 2022. So I'm assuming we're in the middle of proofs.
Yes, Your Honor.
Are there any preliminary matters to be brought to the courts of attention before the people call their next witness?
Just so everyone is aware, the people only have one witness today, Officer CNN. He is currently in the courtroom. I don't believe any sequestration is necessary with one witness.
All right, so we won't invoke the rule for sequestration, but if anybody walks in, let the court know and we'll make sure that the room is cleared. Mr. Wisty, you may proceed with your next witness.
Call Officer Tony Sina.
Officer Senior, have you stand right up here and state your first name and your last name for our court recorder.
Officer Antonio Sina, ANTONIOCENA.
And raise your right hand. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do, Your Honor.
All right, thank you. Go ahead and have a seat, project to the back for recording purposes. And when you're ready, Mr. Wisty.
Thank you, Your Honor. Could you state your name one more time, sir, just for the record?
Officer Antonio Sina,
And where are you employed, sir?
City of Lansing Police Department.
What is your position there?
I am currently assigned to road patrol as a police officer.
Were you working on the night of November 3rd, 2022?
Yes, I was.
When you were working, did you come involved with a situation involving Dejion Richard?
I was, yes.
How did you come to be involved in that situation?
911 had received a call at an apartment complex on City Court. It was
Objection to hearsay.
Response?
I would go for the effect on the lister, not the truth of the matter.
Okay.
Sir.
At this point in time, well, I mean, we were in the date and time. But he can indicate where he was on the date and time. And then responding, we're good with effect on the listener. And then anything else would be subject to a hearsay argument. We'll wait to get there. So I'm going to overrule the objection at this point with the understanding that we would be getting into hearsay once the officer is speaking to any witnesses.
Thank you, Your Honor. When you arrived on the scene, what did you do next?
I conducted interviews with witnesses on scene as they related to the incident.
Just for my edification, what was the scene? Where did you go to?
To the apartment complex on City Court.
Okay, and that's in the city of Lansing?
It is.
Okay.
I was one of those witnesses in Michaela Jane Pentecost.
Yes.
Your Honor, at this point, it would be my intent to ask the officer what Ms. Pentecost said to him. I can prepare to, I believe this would be admissible as a prior statement of a witness pursuant to Michigan Rule of Evidence 613, paren B, extrinsic evidence of prior inconsistent statements of a witness, so long as the witness has been afforded an opportunity to explain or deny the same. The opposite party is afforded an opportunity to interrogate the witness thereon. We had Ms. Pentecost at the hearing last week. I confronted her with the statements, and there was an opportunity for the opposing party to ask her any cross-examination. So I believe what she said to this officer can come in now pursuant to that rule of evidence.
And if I remember correctly, she initially denied making the statement and then indicated that nothing would refresh her memory. And I'm not sure if you attempted to refresh her memory, but she indicated that the police report would not refresh her memory.
Yes, that's my recollection.
Okay. Ms. Robinson, any comment on the any comment on the witness's testimony to what Ms. Pentecost told him at the scene?
Yes, Your Honor. I'm not sure that she actually denied her full statement that was made to the officer in the case. I think that there was one portion of the statement that was denied, and I think that was I think the original, remember talking to the officer. Obviously, we don't have a transcript, so
Right.
I'm just going off of memory at this point. But I believe that is the case. She also went on to state that she did not remember if she said all of the rest of her statement, which is essentially the meat of what the state is going to try to introduce to the officer. And there was no impeachment that was completed or attempted on her at that time. It was simply, do you remember? And no, I don't remember. Recollection wasn't attempted to be refreshed, and the impeachment was improper at that time. And Your Honor, I would like to direct your attention to the case of People v. Harrell. And if I may approach, I do have a copy for
Sure.
both the people and the court. There you go. And specifically, it's head note 10, which I believe is on page 5 of the document. At the bottom of the first page, it basically says that a witness who testifies that he does not remember the occurrence of a specific event may not be impeached by testimony that the event occurred. This is so primarily because the witness testimony does not concern itself with the occurrence or non-occurrence of the event, but only with whether or not the witness can recall it happening. Hence, testimony offered for impeachment to the effect that the event in fact did occur does not discredit the witness's testimony that he cannot recall it. And then it goes on to state that it was error for the trial court to admit it as substantive evidence when it was basically that the witness did testify on direct that they did not remember.
Right. I'm somewhat familiar with the People versus Harrell case. I'll allow the response.
Your Honor, I'd respond. Her testimony was inconsistent with what she said here. She had an opportunity here. I think effectively we had a witness who was not willing to speak to what happened at that point in time. I would argue that her statements that she doesn't remember what happened or didn't see anything happen inside the apartment are inconsistent with the statement she made to the police officer that evening. I would argue that they can be admitted substantially under that rule.
All right. The unlike the Harrell case, the witness was after they indicated, and my notes indicate that her initial response was, "I don't remember," and I don't recall what happened. Nothing happened, and then there was an attempt to, would anything refresh your memory? Would the police report refresh your memory? And she said no. A police report would not refresh my memory. And then I took that not as the inability to remember at that point. I took that as the inability to proceed. That she did not wish to proceed, and therefore any recall was somewhat disingenuous, that she just did not want to testify or was refusing to testify. And therefore, I don't think Harrell applies, because I do think the court, at least under the federal case, I know the court can indicate that the witness refusing to testify and not even indicating that anything would refresh their memory would be inconsistent with the actual event itself, and therefore would be inconsistent with her testimony. She was on the stand. She was subject to cross-examination. The opportunity to cross-examine her was present. So I'm going to allow the witness to testify as to the statements made from Ms. Pentecost under the prior inconsistent statement, with the opportunity to cross-examine. I believe that pierces confrontation, and the witness can testify to that. This also, my understanding is that witness will testify that this is a domestic relationship or a previous domestic relationship, and we have that, at least my understanding. But okay, we'll wait to see what it testifies to. But as a prior inconsistent statement, I will allow the witness to testify. Okay, so with that understanding, you may proceed, Mr. Wisty.
Thank you, Your Honor. So when you were on the scene, you interviewed Michaela Pentecost. What did she tell you?
Ms. Pentecost told me that she was inside the apartment when a verbal argument had broke out between Mr. Richards and his girlfriend. The verbal argument had escalated. It was in relation to a door key.
What happened? What did she tell you happened there?
She told me that Mr. Richards during the argument had become irate, produced a handgun and pointed it at his girlfriend. I believe she made a statement that he said that he was going to kill her. She believed that these actions were going to occur. She was terrified. She actually picked up a small child and fled the apartment.
And then from there, I guess just one final question there. When you were on the scene, did you see the defendant Dejan Richards at all?
Yes, I did.
How did you see him?
Officers went inside the apartment and made contact with him. He was taken into custody and a handgun was secured. I witnessed him exit the apartment and was placed in the backseat of a patrol car.
Do you recognize him here in court today?
Yes, I do.
Would you point him out and identify something he's wearing?
He's wearing Ingham County blue, sitting at the defendant's table.
I mean, the record reflect the witnesses identified the defendant.
Without objection, for preliminary examination purposes?
Yes, without objection.
Okay, without objection, the witnesses identified the defendant.
I have no further questions, Your Honor.
Cross-examination?
Yes, Your Honor, just briefly. Officer Cena, you, when you spoke to Miss Pentecost, you never went inside the apartment complex, correct?
Correct.
And you did not talk to Mr. Richard himself?
Correct.
Okay, so you never saw anything at the scene
You have to be more specific.
inside the apartment, correct? The alleged dispute occurred inside the apartment?
Correct. I did not go inside the apartment.
Okay, and so your conclusion was just based on what she was telling you?
Yes, amongst other witnesses.
Nothing further, Your Honor.
Redirect?
Nothing, Your Honor.
May this witness be excused?
Yes, Your Honor.
Yes.
Without objection, the witness is excused. You're free to leave the witness chair.
Thank you, Your Honor.
Mr. Wisty, any further witnesses today?
No, Your Honor.
Motion for bind over.
The people would move to bind over as to count one, that is assault with a dangerous weapon. The evidence presented to the prior inconsistent statements of the witness, Michaela Pentecost, are that the defendant pointed a gun at Imani Smith and stated that he was going to kill her. This constitutes an assault with a dangerous weapon, the assault being putting somebody in fear of assault, the gun being a dangerous weapon. The people would also be moving to add an additional count, felony firearm as count 2. That's 2 years consecutive with any pending term of imprisonment imposed for felony, attempted felony.
What's the PAC code on that?
250.227B dash A. The underlying felony here is the assault with a dangerous weapon previously discussed. The use of a firearm on that would be the elements of felony firearm. And lastly, we would be adding count 3 for domestic violence second. The PAC code on that is 570.813. The previous conviction of DV was on 54A court, 54A district court, 11/14/2017. That is 1 year and $4,000. That is a misdemeanor. That goes to the assault and the testimony of the officer that Ms. Pentecost said there was a relationship there.
That goes as to the victim in that case would be
Imani Smith.
Imani. Okay. Response?
Yes, Your Honor. Well, first as to the DV, I don't think that she stated any sort of relationship off the top of my head. I don't think that there was any sort of proof that they were in a relationship together or anything like that. Two, as to this case, this is a case that the state is going to have issues with, especially with the fact of that their witness has said one thing on the stand. They brought in this officer basically to impeach that witness. And so it's a battle of what one person said versus what the other person said. The victim is not here in this case. The other witnesses are not here in this case. The other officers aren't here in this case. yet Mr. Richards sits here in custody on this matter. I don't think that there is probable cause at this point to go forward. I don't think that just because we have the statement of what she told the officer and then her statement here in court, I think those basically cancel each other out. And I don't think the state has been able to really prove the case. Further, there's been no proof necessarily that I guess that the victim was necessarily in fear. We haven't heard from the victim at this point. And I think to proceed on this case, I think is to proceed without probable cause. So I would ask that you not bind this over.
Thank you. Any response, Mr. Wisty?
Yes, just briefly, I believe the officer did testify that Ms. Pentecost told them that the defendant and Ms. Smith were boyfriend and girlfriend. That is the basis at this time for testifying on this relationship. And for her not testifying, she's in fear. I believe the standard would be reasonable person in fear. Testimony placing a gun at somebody and saying, I'm going to kill you for reasonable person in fear. Just stated as a probable cause standard at this point.
Thank you. The standard here is probable cause in district court for this preliminary examination. I will go through count one, which is all made through the non-hearsay testimony by definition of Officer Anthony Senna. Really, the first witness called Ms. Pentecost did not provide any type of information other than they were at the date and time at the event, and then they recalled nothing, and then they essentially refused to have their memory refreshed towards the statement. Mr. Senna's hearsay testimony, non-hearsay testimony, pursuant to the prior inconsistent statement, is that the defendant either attempted to commit a battery on or did an act that would cause a reasonable person to fear, apprehend an immediate battery by indicating that Michaela Pentecost told him at the scene that the defendant pointed a gun at Amani Smith, indicating to Amani Smith that he was going to use that gun to hurt her. I think essentially that he was going to shoot her or kill her. And that he and Amani Smith were boyfriend, girlfriend, I think is what he indicated on the stand, that he pointed it at his girlfriend. That this all occurred on the date of 11/3 or 4, 11/3 or 4th of 2022, on or about, I'll indicate 11/4/2022. That's what Ms. Pentecost did indicate, or she did not object to that, at the Sadie Court Apartments in the city of Lansing, Ingham County. That the defendant intended to either injure or reasonably fear an immediate battery. There is an indication from the hearsay testimony that the victim, Amani Smith, was afraid at the time, according to the hearsay statement of Michaela Pentecost, that the defendant had the ability to commit a battery, and the defendant committed the assault with a dangerous weapon, that being a firearm. And that was an object that was likely to cause serious physical harm or death. So count one is met. Count two is the amended count is felony firearm, which goes along at 750.227B-A, felony firearm for the same location, offense, venue, ID, and date, that the defendant did commit the felony of assault and with a dangerous weapon with a firearm at the time. That's a 2-year consecutive felony that's been requested. The court finds there's probable cause evidence based on the hearsay testimony of Anthony Senna to bind over on that count. Count three, the only thing that really indicates is they did say boyfriend, girlfriend. He said according to the hearsay testimony, pointed a gun at his girlfriend, which would indicate that they were in an assault on a dating relationship. There is a prior concerning that matter out of 11/14/2017. That I don't have to find probable cause on. That's a 1-year misdemeanor that'll follow. But I do find probable cause on counts 1 and 2. So the defendant is bound over to circuit court on counts 1 and 2. Count 3 will follow as a misdemeanor pursuant to the complaint filed by the prosecutor's office. Anything else for the record in docket 22-03046, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
Yes, Your Honor, I'd like to briefly address bond.
Okay,
Your Honor, as you can see, Mr. Richard is here and he is in custody. He has a 10% bond. At this time, he cannot post it. While the court has found that there was probable cause for these counts, I don't think there's really any denying it that, the case is not the best for the state. And proceeding further, I think there's going to be a lot of problems for them to prove that. So I think at this point, with the victim being subpoenaed and not appearing, as well as the witnesses having inconsistent statements, I don't believe it's really appropriate to keep Mr. Richard in custody to await that sort of thing. I think that we could keep the community safe by placing Mr. Richard on a GPS tether. He has a pretty limited criminal history. And I don't think there would be anything where he would, go in contact or have contact with the victims, or the community would be at risk if he was kept on a PR bond with reporting to pretrial services and having a GPS tether. I don't think it's fair with, the strength of the state's evidence in this case to keep Mr. Richard locked up on that until we can get a trial date.
thank you. Does the defendant have a valid release address at this point?
I believe so.
There's not one in the file, and there's several indications that that release is not appropriate until the address is somewhat looked at, because
He
there's no
says-
address.
I'm sorry, Your Honor. He says that he would stay at his mother's house. Do you know that? Oh, he left it downstairs in his in
All
the
right.
jail.
I was just saying indicating for the record, at the time of arraignment, there was no valid address, and there was not, Magistrate Milmore, who set the bond, indicated that there was no reason to believe there was a valid address at this time. I find
Your Honor,
that,
if people may,
yeah, you may.
we would just be opposing any bond modification. These are very serious charges, Your Honor. Involved with none of people involved, these sort of things can escalate to serious domestic violence incidences. We would ask for a GPS tether to be in place if he is granted.
Thank you, Mr. Wisty. I was only indicating that because I did not see a valid address, even to release the Mr. Richard to, if the court chose to. The court does not choose to. I believe that the 5,010% is a valid bond, considering that this was a domestic with a firearm, and it has now the 2-year felony firearm included in it, and then there is a prior domestic associated with the file. So the reduction for bond at this time is denied. Anything else for the file on docket 22-03046, Mr. Wisty?
No, Your Honor.
Anything else, Ms. Robinson?
No, Your Honor.
All right, I'll have you sign the bind over. No. Oh, we did. I forgot. So it's held on today's date. And I will sign that accordingly. That's all for the record in this file. Any further dates you'll get from your attorney, Aaron Robinson, in circuit court. All right, sir? All right, we're all set here. Thank you.
Sorry, this isn't on the record. I
Right.
was just looking at the form.